See, today's topic is very, very much important. If any of you will leave in between, then you will not understand what is the topic. And that is very much important if you are going to be in practice. So it will be better. You should join a complete session. So basically, can anybody tell me what is pleading? What is pleading? Can anybody explain? What do you mean by pleading? Okay, tell me. When we are used to go to court, what is our purpose? हम कोर्ट किस लिए जाते हैं या किसी भी अथॉरिटी में हम कोई भी कंप्लेंट क्यों फाइल करते हैं?
Ma'am, to file a petition or written
Pleading are the statements made in writing to the court by the parties to litigation, stating their contentions.
Okay. What is the purpose? What is the purpose of pleading? By filing pleadings, my motive is to present my claim, okay, or
Okay.
defense to that claim. Basically, pleading is a request, a written request as per law, asking a court to grant relief. That is why we are used to file pleading, petition, complaint as per provisions of law. Okay. This is a formal presentation of claims and defenses or counterclaims. This particular point I am sharing you on our WhatsApp group. You can go through that. Okay. So next is what is the purpose of the pleadings? When we are used to file pleadings or our claim or our defense before the court, what is its purpose? First of all,
Literally,
yeah, please. Who was mentioning? Please come on.
Ma'am, we plead our case to get relief, to get justice.
Okay. How we will get relief? How we will get justice? Until unless we will not reveal the facts of the case before the court, how we will get relief? So basic motive of the pleading is to reveal the facts of the case before the court. Secondly, through those facts, the court will settle the issues. Issues means what is the problem which I am facing, which is the relief I want to seek from the other party. Okay. And third one is that to issue summons based on my claims, based on my facts, which I have mentioned in my pleading. Okay. Same is with the other party, means defendant or respondent, whatever be the case concerned. So these are the basic things in pleadings. Basically, our case totally depends upon the pleadings or drafting which we are used to file before the court. Okay. So the main points which we have to keep it in mind in the very first time, if you are going to file any case, whatever be the case, the first document you are going to prepare, it should have complete, means every fact should be completely mentioned therein. Like if you are going to file a complaint in a police station or a CAW cell with regard to domestic violence or dowry demand, in that case, you will have to prepare a complaint since the very first day of marriage of the complainant, and you will have to mention as per date, month and year. ऐसा नहीं कि पहले 2018 का इंसिडेंट बता दो, फिर 21 का बता दो, फिर 19 का बता दो. नो, since the very first day of marriage, and then sequence wise. If the complainant don't remind the date of the incident, then at least she must aware about the month and year of that particular incident, and you will have to prepare accordingly that particular complaint, because the very first document is used to be the base of the case. Okay. Secondly, if sometimes we have noticed that uh, the complainant is used to say कि मुझे याद नहीं है. Don't be in hurry, give her some time to think about. And as per me, what I'm used to do in my practical life, say your client says the very first day of your marriage, date wise, she will have to prepare a written facts or of complaint to you. Whatever had been happened with her since the very first day of marriage, she will have to note it down as per date, as per month, and as per year. Okay. And after going through that particular facts, you will have to prepare the complaint accordingly. If you think something is missing, then you will have to convey this point to the complainant as a lawyer, not as a human being. If there should be connectivity of the incidents, basic point is this. Thirdly, if you are going to file any complaint or any notice which would be the base of the complaint case, it should not be ambiguous. There should be clarity. Which kind of words you are using, it should be very clear. Most oftenly, what we are used to do in complaints, we are used to mention the legal words. Keep this point in your mind, which document we are preparing for our client not to present in the court. There is no requirement to use the legal words. Okay. If you will mention the legal words, then you have seen so many times the police officials or CAWSL officials are used to say, अच्छा आपने वकील कर लिया, because they are used to know about such kind of words, that this particular word is used by the lawyers, and as a layman or as a uh, As a normal public, as a general public, no person can mention the legal words. So, while preparing the complaint, which is not to be submitted in court, don't use legal words. Till yet, I have told you 3 points. First, there should be sequence of incidents. Secondly, there should be connectivity of all incidents. Thirdly, no legal word should be used in any kind of complaint, which is not to be submitted before the court. Next is, we should not forget even a single incident which, as per law, is mandatory to be mentioned as per complaint, or upon which we can claim relief for the complainant. We have not skipped any kind of incident. Thereafter,
Ma'am, can you repeat this point?
last point,
Yes, ma'am.
yes, we should not skip any point upon which we can claim any relief for the complainant in future while filing the case proceedings. Okay, even a you can say small incident, as per a lawyer, it can be a small incident, but if we will corroborate that incident with further future incidents, it can create a big incident. So even we will have to mention the small to small incidents. Thereafter, till yet I have told you four points. Okay. Thereafter, uh, each and every member of family who had or who is committing violence upon the complainant should be enlightened separately with name and relationship. Got it? Thereafter, yes, one more important thing. Generally, what I have seen, we are used to utter to our client, okay, tell what is your story. No, this is not story. These are case facts. If we will initiate with the words, okay, tell me your story, then your client will not be comfortable with you. If he or she is a qualified, then your client will definitely once think he is asking my facts as story. What he will do about the case? Okay, so you will have to use proper words. Okay, let me brief your case facts or your facts upon which you are relying to file a particular case. 99% lawyers are used to do this mistake. This is not the story of your client, these are the facts of his case. Okay,
Ma'am,
each,
but
yes,
as per me, I think that if we tell the client, no, I am not a lawyer and I am just studying a semester two, so it's just hypothetical thing that if we tell the client that tell us your story,
hmm,
he would be more comfortable in telling whatever
no,
it is.
no. when you will come into practice in law, then you will definitely remind my words. Yes, ma'am was telling absolutely right. Law says we are discussing about the facts of a case, not of story of anyone. Okay,
Yes, ma'am.
we are not going to uh, play a game. We are not going to, uh, you can say, we are not going to make any movie or what you say to which we are seeking a story. Okay, so as a sincere advocate, you will have to get the facts of the case. So, thereafter, as earlier I have told you, you will have to mention a specific name with specific relation and with specific allegations. Besides that, if you are having sufficient proofs, no need to mention about those proofs in the complaint, which is not going to be filed in the court. Yes, but we can mention there, in this regard, we have sufficient proofs which can be presented before you whenever be demanded, or which can be produced before the court. There is no requirement to attach those proof with the complaint. Okay, got it? Thereafter, in prayer clause, what is my prayer? What I want through that complaint, we will have to mention that. Thereafter, the name of the complainant, sign, phone number. But before getting her sign, you will have to get a photocopy of that particular complaint, and when you will submit it CAW cell or any other authority, you will have to get the you will have to get receiving on that particular photocopy as proof that we have submitted that particular complaint. Okay,
Ma'am, which authority you said? CWL?
you can find it CAW cell, National Commission for Women, State Commission for Women. Okay, so if we don't find any kind of relief or the relief which we want from that particular authority, we move to court for filing a complaint of Domestic Violence Act. Okay, in that event, again we will have mentioned to every fact of the complaint, every fact of the complaint which I am uttering, that is a particular complaint which we had filed in CAWSL. Okay. Besides that, till the time we had filed a complaint in CAW cell until date, if any kind of further violence or further activity had taken place, we will have to submit or mention those particular facts in our complaint which we are going to file in court for seeking relief under DV Act. Got it? Thereafter, every fact should be in explained and elaborative way. There should be no ambiguity in facts. As per law, the onus of probandi is upon the petitioner, means whatever the petitioner or claimant is claiming, the onus of proving that particular fact is upon the complainant or petitioner or the person who is claiming that particular point. So, whatever we are claiming, we have to file the evidence or proof with regard to that particular claim if we are having. Okay. Every pleading which is of civil nature or quasi civil or quasi criminal should be verified at the end of the plaint or complaint or suit. It should be verified by the parties. Party means who it may be complainant, it may be plaintiff, it may be petitioner. And every complaint or plaint which is of civil nature can be, not can be, it must be supported by sporting affidavit of the complainant or plaintiff who is filing the pleading, who is filing the complaint or plaint. Thereafter, one more point which is mandatory to tell you, there are certain judgments on filing of suits or filing of complaints. As per those judgments, we have to file our pleadings. Like in DV petition, it is mandatory to mention that if the complainant is seeking any maintenance, then it is mandatory to mention that uh, the complainant is unable to maintain herself, and she will have to mention the reason why she is unable to maintain herself or her children. This is a particular point she will have to mention, means a lawyer will have to mention. Until unless this particular point will not be mentioned, the court will not entertain the maintenance point. Okay. Now we come up to written statement. After filing after filing complaint or plaint from the side of first party, means complainant or plaintiff or petitioner, now we come up to the written statement from the defense side. When a lawyer is representing any defendant or respondent, there are certain points which are mandatory to keep in our mind. Every petition or every complaint should be denied, not simply, but specifically, categorically, or vehemently. If we deny the contents of plaint or complaint, generally or normally, as per law, it should be considered as admitted. Supposingly, there are certain allegations in some para. Supposingly, it's para number 3. So, I will have to reply as the contents of para number 3 of the plaint filed by the plaintiff or complaint filed by the petitioner or complainant are denied vehemently or specifically or categorically in toto. In toto means completely. Okay. If we mention it as the contents of para number 3 of the complaint filed by the complainants are denied. Stop. As per law, this denial should be considered as admission. So, we will have to deny any allegation which, as per law, is not is wrong against me. Then I have to mention it as specifically denied, or categorically denied, or vehemently denied. We will have to mention also these the contents of para number so and so are false and wrong. hence denied specifically in total. I'm repeating again, mere denial of the facts is not sufficient. You will have to deny specifically. If you will deny simply, then your contention will be considered as admitted. When we are used to file a written statement or reply to any any application, we are used to mention certain preliminary objections, which are legal objections, and we have to mention those objections in every in every written statement to petition, every reply to any application. There are certain preliminary objections which I will definitely tell you, and you will have to learn those preliminary objections, and as per the suitability of your petition which you have got, you can mention those. Besides those preliminary objections, which is the main bone of contention between the plaintiff or your client, whatever is the bone of contention, you will have to mention that particular point in written in a preliminary objection of your written statement as well. Okay, so till yet you have got it. Any query upon this? So after filing, no, not after filing. Again, a written statement has also been verified by the defendant or respondent, even we can say by our client. And the written statement as well as reply to the application should also be supported by the supportive affidavit of the defendant or respondent. Now we will come up to the replication or rejoinder. Firstly, we file the plaint in the court or complaint in the court. Then the court will issue summons to the opposite party, means defendant or respondent. They will come and file their written statement. After filing the written statement, will give us opportunity to file replication or rejoinder to their written statement. Replication rejoinder, what is that? Means if any point we have skipped to mention in our plaint or complaint, or any point in a written statement of the defendant, it is against me, and to that reply we have to file the replication or rejoinder. Got it? Got what is rejoinder or replication? Thereafter, what is next? Then either the court will state that, okay, now come up for interim argument, means whatever we have claimed as interim relief, the court will say, now come up for arguments. We will go and argue upon the interim arguments, and interim relief have been provided to us. Now the proceedings or pleadings will go to framing of issues. I think you are getting bored. Manikant, you are getting bored, I think.
No, I'm not getting bored. Actually, I just woke up by the notification. Some of my friends said that the class is at 4 o'clock. So I just woke up and I was like, let's do the class.
Okay. So most of the lawyers are used to do a wrong thing At the time of framing of issues, they are not used to go to the court. Even many times I have also done this mistake. I am admitting many times I have done this mistake. We are used to send our, you can say, fresher advocates, our juniors, without giving them any kind of knowledge of the case. First of all, if you are well aware about your case, it is your duty to go to the court or attend the court at the time of framing of the issues. If in any case you are unable to attend that particular date, in that event, you will have to engage any of your junior or any of your intern and describe him these are the issues of the case. While framing of the issues, if the honorable court doesn't take this issue, then you will have to mention this particular point to the court, because judges are also human beings, they can also skip. So it is our duty at the time of framing of the issues, we must reach to the court and know what the honorable court is framing as issues, whether all issues which my client is facing is mentioned in issues to be decided by the court. If not, then we will have to mention, your lordship, this and this are the issue as well, you will have to mention this also. Many times the honorable court is also used to ask, yes, learned counsel, please what tell me what are the issues or what should be the issues as per you. Many times the court do agree upon our issues, and many of the times we are used to argue on that particular point. So my main contention is that at the time of framing of the issues, you must be there as a counsel of your client. If any issue remains unnoted, then how your client will get the claim? Okay, so you will have to note it down. At the time of framing of the issues, you will have to be there. Simultaneously, if we talk about the argument on charge, most of the time the counsel go in the court and state, okay your lordship, charge laga dijiye. What is this? Why don't we think कि mere this statement submitted by the counsel can linger on the proceeding or can linger on the case? I'm sorry to say, some of the lawyer for the sake of money, because many of the new lawyers, many of the fresh lawyers are used to get a fee as per date, not as a lump sum, but as per date. They are used to be under fear कि अगर केस अभी डिसाइड हो गया तो फीस तो खत्म है ना. Why don't you think, if you discharge your client at the time of argument on charge, he will bring to you 10 more clients, he will tell 10 persons more. Always keep it in your mind. नाम कमाओ, पैसा अपने आप आएगा. But I'm sorry to say again, as on today's generation, what I'm seeing or what I'm looking in the court, पैसा कमाओ नाम की जरूरत नहीं है. Got it? There are certain ethics as well. I am following. You will have to also follow. Please just hold down. Yes. Everybody gone? So I was stating that you must have command on your particular law, and don't think that कि मुझे क्रिमिनल लाइन में जाना है, मुझे सिविल में जाना है. At initial point of practice, don't think this. Whatever case you are getting, take it, because this is the profession wherein we are used to learn till the last of our life. Okay, so there should be no specification. If you think I'll go to contest only matrimonial case, supposingly nobody come to with matrimonial cases, then what you will do? Get every case, whatever comes to you, and contest it with your full knowledge. Give your best to your case. Do hard work. Definitely you will learn. Third thing, if you are going to ask anyone about a particular case, this case I got, what I will do? Only 1% are the lawyers here who can support you. Remaining lawyers will, okay, call the client, we will discuss. You will get money. Definitely you will get the money. What is the exposure? You will not get your client, he will not be in your touch. Thirdly, you will not uh, aware about the drafting of the case, how to draft. Money will work for you till when? At any point of time, maybe 5 years, 10 years, you will have to do yourself, na? Then why not at the earliest stage? So my recommendation to all of you is that if you are going to win practice, then give your best. Whenever you will think that this is a case of my client, you will not do. You can't do. Think this is my case. I am not representing that client. I am representing myself in the court. I am to grow through this case. I have got this opportunity to grow and to grow my profession. Okay. So, basic point I have told you of drafting. Rest as far as the preliminary objection I was telling you, I'll share you on mail or WhatsApp as well, because it is hard to tell you on this meet, because it is not possible for you to write in so hurry. There are, I think, 6 to 7 preliminary objections we are used to mention in the written statement or reply. So I'll share it to you either by tomorrow or day after tomorrow. I'll try to share it by tomorrow itself. Okay. Is there any query with regard to this particular topic which I have told you?
No, ma'am.
Everybody is clear?
Yes, ma'am.
But still, I'll continue this topic for tomorrow, because there are certain things in certain other cases which I think I should tell you, so that there should not be any kind of ambiguity in your mind with regard to drafting of the cases. Okay, so see you tomorrow.
Okay, ma'am.
Okay, bye.
Thank you, ma'am.
Welcome.